Thanks for joining us once again. You're still on the POLITY, reaching you live from the nation's capital. And now, one particular factor responsible for congestion of detention and custodial facilities is the difficult bail system and perceived reluctance of judicial officers to grant bail to inmates, especially for offences that are ordinarily bailable. Now, for decades, there's been a steady rise in the Nigerian prison population. Now, the prison population in the country comprises of adult males and females and young persons. Not just that, more than 60% of prison admissions are waiting trial or being remanded in custody. Now, this overcrowding has led to side effects that inmates experiences, and they include damage to physical and mental health and human rights violations. And now to talk about the decongestion of the Nigerian prisons in Nigeria with me is a legal practitioner that's in person of confidence, Mbang. Welcome to the program.
Thank you so much.
All right, so let's get to it straight. Of course, everybody, I think it's no longer news that the Nigerian prisons are congested right now, and like I just said, now most of these people there, they are still awaiting trial, and you see people from 4 years back, 5 years back, still awaiting trial. And let's not even talk about the Nigerian judiciary to start with. What's your own general overview about this?
I would say that the issue of prison congestion is actually not good at all for the administration of our criminal justice system.
Okay.
And of course, many times it results to the violation of the right to liberty.
Okay.
Yeah, because every citizen have this right, your right to liberty, and of course the right is being captured in international, regional, and national instruments and laws. For instance, Article 9 of the Universal Declaration of Human Rights, 1948.
Okay.
It states that nobody should be subject to arbitrary detention and exile. We also have Article 9 of the International Covenant on Civil and Political Rights. We also have Article 14 of the United Nations Charter, Article 6 of the African Charter, and Article 4 of the ECOWAS treaties.
Okay.
And back to our own jurisprudence in Nigeria, Section 35 of the 1999 Constitution of the Federal Republic of Nigeria, as altered, guarantees this very beautiful right to liberty. And so, but then what we see in our criminal justice system is that this right is being violated day by day by the law enforcement agencies and institutions involved. And so this has resulted to congestion of the prisons.
Okay.
And of course, I know you may wish to know what are the major factors causing congestion in our prisons.
Yeah.
Yes. First of all is the high rate of crimes. Yeah, because we observe that citizens engage in criminal activities, and so.
But then, sorry to cut in. Who actually do all of these analyses? Because does this a case of people that are just picked up for no reason, for nothing, and then I heard some stories a few years back where a man said he just stepped out of his house to get few things on the street, and then he was picked up by police, and then next thing he ended up in police officer's mess, and then he was pointed to as the person they were looking for. Meanwhile, he doesn't even know anything about what they're talking about, and it's still awaited trial for over 5 years, and I think it was years later he was released, and they said, oh, he was not the person they were looking for. So now, looking at all of this together, apart from human rights lawyers that actually fight for justice of the people, what is the federal government doing? And then talking about the freedom of rights and of course liberty to be able to express yourself and all of this, do we have any guidelines in Nigeria actually just to set the record straight with these people, because now that the prison is congested, of course, most of them has to be moved. But then when 80% or 60% of them are waiting trial, how does that even happen? Okay,
yeah. First of all, I must say our law enforcement agencies, they are not stupid to just pick you up. No. The police arrest based on reasonable suspicion.
But you agree with me that that's not all the time?
Well, after investigation proves same.
5 years after?
That is where we are having the problem. The police must increase their speed in respect of investigating criminal offenses.
Okay.
Yes. So, but then we talked about safeguards, section 35 of the Constitution. Okay. 35 sub 1 says you lose your liberty when you are being charged to court or being investigated for an offense and all of that. Now, the problem is that when they arrest you now, the law says that you should be charged to court within 24 hours or 48 hours, as the case may be.
Maybe, yeah.
Yes. When you're charged, your trial is supposed to commence instantly. But the problem is sometimes the law enforcement agency will not have enough evidence to prosecute you instantly.
So if you don't have enough evidence to prosecute someone instantly, why should you even make the arrest to start with? I think people should be arrested based on, oh, you've concluded your investigation and you've concluded the fact that, oh, this is a possible suspect.
That is why we have what we call remand proceedings.
Okay.
Yes, and before 2015, the enactment of the Administration of Criminal Justice Act, we operated remand proceedings via holding charge, where the prosecutor will take you to a magistrate court that don't have jurisdiction to try you. So the magistrate now will just remand you pending when evidence are being gathered to fully prosecute you. So it is in the stage of that remand that suspect may remain there for 5, 6, 7, 10 years.
10 years.
Good.
Exactly.
Yes.
Now, imagine someone has wasted 10 years of their life. Shouldn't we have a law or provision should be made for deadline for all of this research, say in 34? The same way you should have been checked to prison in 24 hours. Then if after 24 hours you've not gotten this thing, then I think you should be released.
Beautiful. That is why we now have section 293 to 299 of the ACJA.
Okay.
That provides for highest 56 days remand.
But we don't follow that.
Which is in line with section 35 sub 4 and 5 of the Constitution.
Okay.
Which says you may not be tried within 2 to 3 months even after you have been charged. Now, the problem is, irrespective of these mechanisms, why are our prisons still being congested, especially with awaiting trials detainees? Now, on the 6th of September this year, just last 2 months, because you asked
already.
Yeah, you asked what the federal government is doing about that.
Okay.
Right Honorable Olobumi Tunji Ojo, the Minister of Interior, yes, he came out and he said, look, we are ready to partner with the Ministry of Justice to ensure that our prisons are decongested. And everybody was and is happy about that. Then after that, some few days, renowned human rights activist Femi Falana SAN came on board and said no, that the minister should consider consider his choice of paying 500 million for 4,000 inmates. That instead of that 500 million should be used to cater for welfare for these inmates, that there are other alternatives to decongest the prisons. Now, what are these alternatives? The first alternative is, look, follow the procedure as provided in the ACJA strictly, and believe me, there will be no congestion in our prison. Because now, as of 30th October, few days ago, the statistics summary from the Nigerian Correctional Service on inmates presently in Nigeria now, 36 states and the FCT, we have 81,134 inmates. Now, for inmates that were actually convicted, we have 25,633. That is 633.
So that's 81,000 minus 25,000.
Yes.
Lord.
So the inmates we have awaiting trial now is 55,501 inmates. It is lugubrious, it is scandalous, it is incongruous, it is very abysmal. In fact, it is a shame to our criminal justice system, because those are
the ones you even make calculations for, because some are probably were not even charged or not awaiting trial.
That is the problem.
Some were just locked up.
Thank you. Take for the instance now, there is this popular case, Sikiru Alade against Nigeria. After this, Google it. That guy was charged to court 2003, and he was sent on remand. Guess what? He spent 9 years there. It was in 2012 that I think Open Society Foundation or something went to the ECOWAS court, and the ECOWAS court granted his release and damages of 2.7 million as of 2012. So there are so many of those cases, and that is why the stakeholders are, I'm talking about the law enforcement agencies, that is the police, EFCC, ICPC, all of them, the judiciary, the Nigeria Correctional Service, the NGOs, all of them must come together, partner, synergize, and make sure that they decongest this prison. I really love what the Minister of Interior is doing, but then I feel that he should engage more stakeholders and activists to show him how this can be actual. He's talking about 4,000. To me, it is too small out of 55,000. No. But then my suggestion is that we hope, Nigerians are hoping that, look, the 4,000 should be his first phase. After the second, at least 30,000 before he leaves office. In 4 years or 8 years time. Yeah. So there are alternatives to decongest prisons. For instance, Section 34 of the ACJA says the Chief Justice of Nigeria and Chief Justice of the various states should carry out monthly visits to correctional centers.
And not even with the cases they have.
Again,
do you think they would have that time?
The president and the governors of the states, by virtue of Section 175 and 212 of the Constitution, they have the right to grant pardon. Pardon. They have this right. We also have non-custodial sentences, more introduced by the ACJA. Instead of sending these guys to the prisons, why not? They should pay fines. They should do community service.
But if you say they should pay fine and do community services, isn't that isn't that what's enabling criminals to work freely in society? Because even I remember a few years back when they brought out members of the Boko Haram people that they caught, and they said they were sent to rehab. Of course, there was an uproar in Nigeria and say, oh, why not just go to the prisons and even bring out the inmates instead of people that have killed, that have done things, and it feels like they're enabling them. But don't you think that's like handling with levity? Yes, I'm still all for people should be judged, but I'm just fighting for the fact that there are some persons that have been dead 5 years, 8 years and waiting for trials, and there are some persons that have never gone to court. I mean, I've heard stories like that from people that do prison merry-go-rounding. I don't know what they call it there, but then that's a lot. So what is your I think I'm someone that talks about problems, and we'll talk about the solutions too instantly. So to all these things now, I'd like us to wrap up in a few minutes. What do you think is the best solution the federal government can actually prefer to let most of these persons go? Because I mean, you yourself, you said 4,000 naira is little compared to 55,000 or over 55,000 people that are there.
Well, the best approach to decongest our prisons are: one, strict compliance with remand procedures. Number two, utilization of non-custodial sentences. Review of the objectives of sentences. We have the 3 R's: reorientation, rehabilitation, and reintegration. They should go back and look at it well. Prison visits by justices.
Okay.
It should be carried out. Then the role of the ACJA monitoring committee, they should ensure that everything is put in place in line with the ACJA.
Okay.
Then human rights activism and crusade by lawyers, activists, NGOs should actually continue as we are doing now to ensure that our prisons are decongested. If not, the enigma will continue.
And I would like to ask 2 questions as we round up. How good or manageable is the welfare of those inmates in this prisons if the prison is even said to be congested right now?
Well, I don't know. I think they have their practices there.
Practices, but okay.
Yeah.
Okay. So as we wrap up, I'd like you to leave a note with the federal government, because of course most of this is left to the federal government to be able to say, oh, they are going to free up space and actually allow the real criminals to be held there.
Okay. My word to the federal government is that, look, the Minister of Interior have taken a very good step, and so the federal government should gather the stakeholders and look for more options, just like Femi Falana SAN have said. There are alternatives. Look for them, implement them, and I bet you our prisons will be decongested, because a situation where out of 100%, 68% of inmates are awaiting trial is very incongruous, if you ask me. So that's it.
All right. Thank you very much, Confidence Mbang, for joining us today on the Polity. We do hope you would have another time to, of course, talk more about it. And then before then, we would probably have a report on the prison congestion before you come next time. Thank you for joining us today on the program.
Thank you so
All
much.
right, our viewers at home, thank you for joining us on the Polity for this week. And of course, today, this is where we wrap it up and draw the curtains for the Polity. I remain Mercy Babajide. See you same time, same station, and remember to stay safe out there. All right, bye.